Canada, and good afternoon to our colleagues from UK and other parts of the world. It's my sincere pleasure to host this wonderful event today. I am your host, Rakesh Kumar Khanna, Senior Advocate practicing in the Supreme Court and High Courts in India. I am the former President of the Supreme Court Bar Association, and prior to that, I have also served as the Additional Solicitor General of India. Currently, I am an appointed member of the Executive Committee of the Supreme Court Legal Aid Committee, and I am also Certified Mediator by the Supreme Court of India. Most of you may already know my co-host, Mr. Thiru. Mr. Thiru is a senior litigation lawyer based in Kuala Lumpur, Malaysia. He is the Vice President of the Commonwealth Lawyers Association, Australiasia Hub. He is also Vice President of the the Law Association for Asia and Pacific. And he has also served as the former President of the Malaysian Bar in the past. Mr. Thiru will be delivering the welcome address today. My co-host, Mr. Rajiv Dutta, is Senior Advocate and Mediator at the Supreme Court of India. He is a former Vice President of the Supreme Court Bar Association, and he will be moderating today's session. Lastly, my co-host, Mr. Aruneshwar Gupta, who is a Senior Advocate practicing before Supreme Court of India and the head of the Sports Dispute Resolution Center of India, will be giving the vote of thanks. Friends, the Mediation Center in the Supreme Court of India was started 10 years ago, when the first batch of 40 lawyers were trained by the center. Last year, another batch of 50 lawyers were trained, and this initiative breathed new life into the center. Continuing ahead in that spirit, we, the mediators at the Supreme Court of India, along with Commonwealth Lawyers Association and Youth Bar Association of India, have started these international webinar series on post-COVID mediation to help chart the path of the future. In our very first webinar of the series, we had approximately 1,500 registrants, and as of date, that webinar has more than 28,000 views on the YouTube. The second webinar of the series focused on resolving instead of adjudicating disputes. This again was a very well received and was huge success, having over 1,700 registrants and several thousand views on the YouTube. Besides these international webinars, the Supreme Court Mediators, along with Youth Bar Association of India, have also conducted a summer school workshop for law students. In this workshop, we conducted a series of 11 lectures on the process and procedures of mediation. I would also like to mention one last noteworthy initiative that we, the mediators of the Supreme Court of India, have recently initiated. We have begun to conduct a bi-monthly lecture series as a part of our effort to continuously updating ourselves with the latest developments in the field of mediation and refresh our mediation skills. The next lecture in this series is scheduled for 22nd of this month. Coming to today's topic, I believe that the basic philosophy of the sports lies in the sportsmanship of the players and other stakeholders. Their virtues, such as fairness, having a positive attitude, self-control, giving one's best efforts, having an accommodating nature, putting in one's best efforts, not indulging in unnecessary arguments with the opponents and officials, displaying honor, discipline, kindness, resilience, perseverance, etc., truly ties in with the essence of mediation. Furthermore, today, sports have become an industry involving numerous players, officials, sports bodies, and other stakeholders. The issue of discussion today assumes a greater importance when it comes to resolving the disputes between these parties. To discuss some of these important aspects operating in the world of sports, we have a highly distinguished panel of internationally acclaimed judges, players, and mediators amongst us today. I'm not taking time to introduce my panelists. That will be done by my co-host and the moderator, Mr. Rajiv Dutta. With these words, I request my co-host, Mr. Stephen Thiru, to give his welcome address. Thank you. Mr. Stephen, please unmute yourself.
Thank you, Mr. Khanna. Distinguished panel members, ladies and gentlemen, greetings and welcome to this webinar organized by the Mediators of the Supreme Court of India, the Sports Dispute Resolution Center, and the Youth Association of India. May I, at the very outset, on behalf of the Commonwealth Lawyers Association, express how pleased we are to be a supporting organization and to associate ourselves with this important webinar. As you've heard, this is a series of webinars that have been very successfully organized with a reach that spans the width and breadth of the world. I wish to welcome all the panel members who will be individually recognized and introduced by the moderator later. And I wish to personally convey my thanks to them for setting aside their time and the effort that they put in to contribute to this event. And of course, I wish to welcome you, all the attendees, the many attendees that we have who are online, who have taken time to attend and to participate in this webinar. I just like to share something with you. We had what is known as a dry run yesterday with the panel members in preparation for this webinar. Now, if that dry run is any indication of what you are about to receive and witness today, then I must tell you, you are really in for a treat. The enthusiasm, the level of preparation, and the equity to the issues that I heard and saw last night was truly impressive. And we are really in for a very good seminar today. Ladies and gentlemen, the scope of mediation in sports disputes is something that is a contemporary matter, a matter that is important and relevant. The experts that we have today in the panel will give you their views based on their diverse knowledge and experience. And you'll see that when they speak and for the different viewpoints that they have. And they, of course, cross jurisdictions as well. And so you'll see the different approaches that have been taken in their respective jurisdiction. If I may say so, it's not often that you have this opportunity to hear such a collection of experts giving their views based on the views coupled with their varied experience. You know, there are many downsides to this pandemic, and we all know that, and many of us can go on and on about it. But if there's one silver lining in it, it is this: it is improve the connectivity that we have throughout the world. Many of us would not have been able to participate in a webinar like this and get speakers of this quality under one roof for one event if we were to do it physically. The costs, the travel, all these are prohibitive factors. But today, perhaps because of this pandemic, here we are able to actually connect, and that is something that I think we should be grateful for. And we must, in that spirit, take full benefit of this webinar. The other aspect of this this webinar, and which must not be lost, is again perhaps a bit of an offshoot of the pandemic that we are going through. In many of our jurisdictions, court proceedings are in fits and starts. We are not able to practice and appear in the courts as we have been in the past. And you have increasingly demands from clients that there should be some way in which the disputes can be resolved, an alternative dispute resolution mechanism. So in that spirit and in that vein, you see that mediation assumes prominence and importance perhaps never before, not just in sports dispute resolution, but almost in every area of dispute. So many a lawyer today is cooling himself or herself afresh in mediation and preparing themselves to be able to mediate and act as mediators, or represent clients in mediation. That is something I believe should not be lost, although we are in a very specific discussion today, but that underlies our discussion, underlies the new normal, if you like, in the way in which we practice law. That's really all I want to say as part of the welcome. I do realize that I stand in between you and a great webinar. And the matters I've raised are just minor matters, and there'll be wiser minds who would come and contribute to the substance of this webinar. But before I go, I just wish to make a small marketing pitch for the CLA. The Commonwealth Lawyers Association would have our annual conference next year in the Bahamas in September next year. And we are planning still for a physical conference to have as many of you come and join us there. And there would be room for mediation and scope and sports law in the program that we have planned for the conference. So I wish you a good webinar today, and I know you will have a wonderful time. Thank you very much.
Thank you very much, Rakesh ji, and of course Stephen, for the kind words, and also the distinguished panel here and all the participants. We are actually in for a very, very exciting evening. Let me tell you at the outset. We have a stellar cast of speakers today for you, and it will be a very, very exciting evening. And let me also add that amongst the sessions that we have had so far, we have had a very, very exciting season. And as you have already been told, despite the manner in which the whole world has come to a standstill, we have planned these webinars to take us forward and make us learn more and more about whatever subjects we want to indulge in. And at the outset, I want to say this is really an international webinar, and the speakers we have today are those who are absolutely giants in the field of arbitration and, of course, sports mediation. All over the world, they have practiced, and they have learned, and they have communicated in these subjects to such an extent that you will very soon learn. And therefore, I don't want to say anything more. The subject that the scope of mediation in sports disputes, is a subject which is fairly, as far as India is concerned, is a new subject. But as you all know, sports disputes majorly evolve around team selection, funding, doping, disciplinary measures, governance of federations, validity and implementation of government policies, etc. And sports has its own culture, ethos, philosophy, interest, etc. Now, let me at this stage straight away, without wasting any time and coming in the way of the speakers, let me introduce you to the first speaker that we have today evening. The first speaker is Deryck Murray. Deryck Murray is a world-renowned sports person, as you all know. He's a former West Indies cricketer who has served as a diplomat in the Foreign Service of Trinidad and Tobago. Mr. Murray has also worked in the financial services industry in the United Kingdom and in the Trinidad and Tobago. An alumnus of Queen's Royal College, Port of Spain, he studied at Cambridge University, where he was a cricket blue, and at the University of Nottingham, from which he graduated with a BA in Industrial Economics, and where he also received a Lifetime Achievement Award. As a cricketer, Mr. Murray played 62 tests from 1963 to 1981 and was vice captain of the West Indies team that won the 1975 and 1979 Cricket World Cups. Deryck is also an accredited mediator. Mr. Murray has been recently appointed as a Trinidad and Tobago's High Commissioner to Jamaica and is the current chairman of the Commonwealth Advisory Body on Sports. Let me invite you, Deryck. Please, we are all very anxiously waiting to hear you. So please come forward and give us your learnings on this topic so that we can be educated and also enjoy this. Thank you very much.
Thank you, Justice Dutta, for that introduction. And also, at the outset, let me thank the Commonwealth Lawyers Association, the Youth Bar Association of India, and the Sports Dispute Resolution Center of India for affording us the opportunity to discuss what is becoming a very fascinating topic. I also thank Justice Khanna and Mr. Thiru for their kind words of welcome. So while we always consider sport for its values in terms of sportsmanship and all the rest that goes with it, we do unfortunately have far too many disputes arising in sport that do need resolution if we are to enjoy the benefits of sport as we all love. And I think that's the important thing about entering into discussions about sport, that it is propelled by the passion and the love that everyone has for sport. And it plays a very special role in our lives. And certainly I'm biased because I was actually a participant, so I have it from a different perspective. But when we look at the disputes that threaten sport, we need to find ways to resolve that in terms of being able to employ processes of resolution that will maintain what is fundamental to the laws of any sport, which is the spirit of the game. Something that is unwritten, but everyone who participates feels acutely. Mediation is what we are discussing today, and I will use that definition on the screen, which is a structured interactive process to assist disputing parties in reaching a settlement. And the important thing is that mediation provides an opportunity for the parties to fashion the solution as the mediator moves through the process. But in many ways, the philosophy of mediation is the very antithesis of that of sport. Sport is played basically to win. And therefore, when you come to dispute resolution, usually the party's instinct is to win, to win their point. And the great thing about mediation is that simply by choosing mediation as the process, and remember, mediation is a voluntary process between the opposing parties. It allows for negotiating, for changing positions, and it puts the mediator as simply, and I use the term guardedly, the facilitator of the resolution. And it is the parties that have to move their positions in order to function and fulfill the need for a resolution. When we examine the competitiveness of sport, we recognize that while sportsmen play to win, they want to play on a level playing field, so that within the game, within the sport, there are usually very conspicuous judges, facilitators for the game itself, whether they be the referee, the umpires, in whichever sport, football, boxing, cricket, netball, wherever we go, we have people who, as sportsmen, you learn to accept the word of the umpire, the decisions of the umpires as the game progresses and goes along. Notwithstanding, nowadays we have all the electronic assistance for the referees and judges and so, but very often it is a question of the interpretation of the rules and regulations. There are very subjective decisions made throughout a game, whether it's a foul, whether it's offside, whether it's a handball. You know, you look through all the games and you recognize that the participants themselves learn from a very early stage in their careers that they have to accept the decisions of the adjudicators. And so mediation is an extension of that. And therefore, choosing the mediator, choosing the facilitator for the process of mediation, what that dispute may be, requires first a mutual agreement as to the acceptability of that facilitator. So requiring that facilitator to be trusted, to be held in esteem, and also one who understands the requirement, not just for arbitrating a decision or a point, but actually encouraging a movement of people's positions, and therefore looking at the compromises. So whereas you may have an issue that is going to be mediated, and it's usually a conflict between opposing administrators possibly, or players and officials having a difference of opinion about access to facilities and resources, athletes versus the controlling body of a sport, whether it's an international body or whether it's an internal national matter, and whether it's to do with contracts, scheduling of events, restraint of trade. It's all a question of how do we manage that process. And then there are other issues. And we talk about selection, and which is almost a very basic requirement of putting out teams, selecting competitors to take part in international or regional games. And therefore, it is always a question of the subjectivity of the people put in those responsible positions. And it often looks, whether it's through the National Olympic Committee, whether it's an International Athletics Federation, etc., that those interpretations of how these elections come about, whether they are done through nepotism, cronyism, etc., it's the perception of how these things are done, which creates in the participants' minds, or in the minds of anyone on the periphery, it creates angst, it creates anxiety, it creates situations which are not conducive to what sportsmen want in terms of being able to compete on a level playing field. But while there will be a headline issue, whether it's poor financial management, whether it's poor team selection, whatever. There will be other issues related to that, which a skillful mediator, rather than strictly an arbitrator, can introduce subtly into the conversation to draw out those issues, whether it's an issue of gender bias, racial prejudice, the safeguarding of athletes, very delicate, sensitive subjects, which may not feature as a official headline issue, which we want to talk about. We haven't come here to talk today about racial prejudice. So we want to deal with it as an issue on the field of play, or concerned with the conditions of rules and regulations and interpretation. But it is a real, very serious, very sensitive, very important issue that has to be addressed at some point. And then there are the wider issues as well, because as we all know, sport is a catalyst that can help nations contribute to the achievement or attainment of the sustainable development goals. And there are so many things that go around sport that need to be addressed, and it's very often difficult to find where is the best place to address those issues. So just to mention a couple of the topical issues of the day, and again, I know that Louise will talk much more about this later on when we talk about bodies like the Court of Arbitration for Sport, which in years gone by has been considered the final arbitrator of decision. So very much like some of us would be accustomed to matters going to the Privy Council or something like that in a legal sense, you have the Court of Arbitration for Sport. But let me just use two things as examples at differing scales. There is the issue of Caster Semenya, the middle distance athlete from South Africa, and the recent decisions, without going into the legalities of the decision, etc. The perception is that the decision favored the ruling body, in this case the Athletics Federation, but also there are the underlying issues that is it racial, is it of other issues that played a part in it. The main thing is that decision would prejudice the way people now look at the Court of Arbitration for Sport. Is it something that arbitrates and regardless? Is it something that has a systemic bias in favor of the ruling body? And I then use, on a much smaller scale, which many of you may not have heard about, an issue with FIFA. Not always my favorite body, although a sport that I love to watch. But FIFA recently introduced a normalization committee and suspended Trinidad and Tobago's football. Again, without going into the whys and wherefores, when the Trinidad and Tobago Football Association that was being removed from its administration, they chose to bring the matter to CAS. However, CAS imposed a penalty, or sorry, not a penalty, imposed costs on the Trinidad and Tobago Football Association, $60,000. FIFA had to pay nothing towards the cost of the arbitration, mediation, whatever was the dispute resolution. Immediately, therefore, it smacked of bias. Why should the Football Association, which is bringing a matter to CAS for redress, have to pay for the costs of the thing, but not FIFA, who is the other party? So regardless of the rules, regulations, the laws, the way that CAS operates, it then gives the impression that we're talking about the big guy and the little guy. And the little guy just accepts what the big guy does and moves along and mustn't say anything. Otherwise, you fear suspension. But the perception of the arbitrating body, or the body that should be conducting mediation in such an issue, tends to be seen, certainly in the Caribbean and some other parts of the world, as Western-centric. So again, they have different rules and regulation. I always think and uphold the beauty of Usain Bolt's performances over the years. And I understand that he has been the most tested athlete for drug tested ever. Which again seems to suggest that the authorities, the establishment as such, is looking to ensure that such an athlete is not allowed to go through a career without saying, you can't be so good, you have to be taking drugs because you are not from the establishment. So again, I throw that out, and as maybe why not just seeking mediation, but seeking the body to conduct the mediation, and then the individual who is chosen as the facilitator, which goes to show that the preferred method of resolution for me would be mediation, especially for sport, where, as I said at the outset, the rules must take into account the spirit of the game. And what is so important after the result is the relationship between the opposing parties to the dispute going forward, because it's the only way we can learn, we can have continuity and have stability in sport. At the end of the day, even the athletes, as much as they want to win within the rules. They want to believe that they've just not won an event or game or a match, but that they did it on merit. They deserve to be esteemed, and they want to show respect for the other participants, the other competitors. And so what we are aiming for is not just achieving harmony, good sportsmanship, but actually aiming to encapture the Corinthian ethos. Again, I throw that out for your consideration, and I look forward to the contributions of my esteemed colleagues on the panel. So thank you very much for having me, and I hope we have a very productive day. Thank you very much indeed.
Thank you very much, Deryck. And I must say, your whole speech was also propelled by passion. And what a brilliant, expose on all the aspects of mediation, and especially your comments that the players, they learn, it's in their DNA. They learn to respect the empire, and it's the attitude of play to win on a level playing field. That is what impassions them. And if they succeed and they learn that it was not a level playing field, it would be not so welcome to them. And sports is a catalyst to sustainable development. What an energetic thought! I mean, it's something simply so marvelous. And of course, I think the next speaker that we have is Louise J. Reilly. Louise, let me introduce you. Louise is a barrister who specializes in sports law and international arbitration. She represents clients in regulatory and disciplinary matters before domestic and international tribunals. Ms. Reilly also sits as an arbitrator. She represents Ireland on the ICSID panel of arbitrators of World Bank in Washington, D.C. She is Washington, D.C. is the Irish alternate member of the ICC International Court of Arbitration in Paris, and is a member of the panel of arbitrators and mediators of sports resolution in the United Kingdom. Ms. Reilly is regularly appointed by international sports bodies to investigate allegations of wrongdoing. She is a member of International Weightlifting Federation, Independent Member Federation Sanctioning Panel. Ms. Reilly is chair of the board of International Biathlon Union's Biathlon Integrity Unit, which she puts the sports of biathlon at the forefront of good governance in international sports. She is a board member of Paralympics Ireland. Ms. Reilly is adjunct associate professor of law at University College Dublin. She has also held positions as adjunct as assistant professor of international dispute resolution at Trinity College Dublin, and visiting professor in international arbitration at Western Law School, Ontario, Canada. Prior to returning to private practice, Ms. Reilly was managing counsel and head of mediation at the Court of Arbitration of Sports in Lausanne, Switzerland. She began her career as deputy counsel at the ICC International Court of Arbitration. She is a former judicial intern in the United States District Court for Central District of California. Ms. Reilly is a graduate of Trinity College Dublin, the Honorable Society of King's Inn and Stanford Law School. While at SPILS Fellow at Stanford, she conducted empirical research on the role of arbitration in resolving business and human rights disputes. Ms. Reilly, we are so proud to have you here today. And I know you, everybody is really waiting to hear you. And after the speech that Deryck gave and the passion that he drove in, I think we are absolutely ready to hear you. Thank you very much.
Thank you very much, Mr. Dutta, and thank you for that very kind introduction. I will hope to, but I'm not sure I'll be able to match Deryck in his enthusiasm and passion. But thank you very much, Deryck. I very much enjoyed your contribution. Before I turn to kind of the crux, if you like, of what I'm going to discuss, just to address maybe or to comment on some of the very interesting points which Deryck raised. One of them being whether there is systemic bias at the Court of Arbitration for Sport. I suppose my gut reaction to this is no. I think if you look at decisions of the CAS, and it would be a very interesting empirical study to do to really go through each decision and find out statistically in what statistics did the CAS find for or against the sports body, the International Federation. I don't have those stats. I'm not sure they're available, but I think even just to look at recent decisions of the CAS, so 3 decisions that come to mind immediately were decisions issued in September by the CAS against 3 biathletes, or in which 3 biathletes took appeals to the Court of Arbitration for Sport. Those cases were taken against the International Olympic Committee, which of course is one of the foremost sports bodies internationally. And it's interesting to see that in those, there were 3 cases taken, 3 individual cases. And in those 3 cases, the CAS ruled for the athletes in 2 cases, so against the IOC in 2 cases, and against the athlete in 1 case, so for the IOC in 1 case. So based on, I mean, that's not obviously any kind of empirical study, but there it's just a recent example of where the CAS ruled against the IOC in 2 cases and for them in 1. But it is, look, it's a very interesting point, and I think it is something that will continue to be discussed, particularly when you look at the structure of the CAS and the international federations and the power they hold in the field of international sport. But that's, as I said, just a brief comment for what it's worth on that point. The second kind of very interesting point which Deryck raised, which I'd like to just to briefly comment on, if I may, is a perception that the CAS is Western centric. And I can fully appreciate and understand this in circumstances where the CAS court office is based in Lausanne, Switzerland, where the seat of arbitration for every arbitration is Lausanne, Switzerland. So the underlying procedural law is invariably Swiss law, apart from some exceptions. Again, there, I think the CAS has taken steps, and I say this from my own experience. I don't obviously speak on behalf of the CAS, but I think if you look at steps the CAS has taken in the last number of years to try and be more geographically representative. So, for example, if you look at the list of 400 or so arbitrators, they come from regions all around the world. They represent 87 countries from around the world. The CAS, although the headquarters are in Lausanne, the CAS has established alternative hearing centres in Abu Dhabi, in Kuala Lumpur, in Shanghai, and in Brazil. I'm not sure if it's in Rio or Sao Paulo in Brazil. But again, if you like, efforts made by the CAS to be a more global offering, if you like, to the users of the service. But again, it's a very interesting point raised by Deryck, and again, it's something that I think will continue to be a point of interest and of discussion. In terms of what I hope to contribute in the brief time in which I'll speak to you today, what I'd like to look at first is just to give an overview of the CAS mediation rules. I think when I go through briefly what the rules set out, you'll see a lot of the principles which Deryck referred to are enshrined in the CAS mediation rules. And in the second part then, I'll just go through a couple of examples of mediations I was involved in, of sports mediations I was involved in, and the takeaway learnings I got from those disputes. So just looking first at the CAS mediation rules, and these rules are available on the CAS website. They're effective, the rules are in effect as of the 1st of January 2016. So similar again to kind of the general principles of mediation. Mediation before the CAS is non-binding. It's an informal procedure based on the parties' good faith attempt to negotiate. So really you need to start from a place where the parties are both in good faith attempting to negotiate a settlement to their dispute. The CAS rules specify that the mediation is for the resolution of contractual disputes. So where you have a financial amount in dispute. The rules specifically exclude disciplinary disputes, such as doping issues, match fixing, corruption. Although there is a caveat there that the CAS rules say in certain circumstances, the parties may agree to submit such disciplinary issues to CAS mediation. So the rule is disciplinary matters are excluded, but there is that caveat that in some circumstances, and what those circumstances might be, I suppose, is a matter for debate. In terms of who gets to decide or help you resolve your dispute, the CAS has a list of mediators. So they maintain the list. I think there are perhaps around 60 mediators on the CAS list, again, coming from various different parts of the world, and they're available to act as mediators on the understanding that, of course, all mediators are impartial and independent of the parties. And really the role of the mediator is to identify the issues in dispute. So to help the parties whittle down what are the issues in contention between them, to facilitate discussion. And also a important feature of CAS mediation, which isn't available under all the rules, is that CAS mediators specifically have the role to propose solutions. So they identify issues, they facilitate discussion, and they have that power under the rules to actually propose solutions to the parties. Now, of course, they're proposals only, they're not binding. The mediator doesn't decide a case, he or she simply tries to find a resolution with the parties. It's interesting to see how these run in practice. Mediators, again, under the CAS rules, have the power to communicate with parties individually. So one of the golden rules of arbitration, by contrast, is that arbitrators cannot have one-sided communication with the parties. In mediation, the situation is different. In mediation and in CAS mediation, the mediator has that power to have one-sided communication with the parties. And that's very important and that's very useful because it allows the mediator, in advance of any mediation meeting, to have these conversations with parties, to build up a relationship of trust and to find out where are the parties. The parties may have an opening position vis-a-vis their opponent, but really it gives the mediator an opportunity to figure out where do areas of concession lie, and also to try and establish what are the interests. So the parties may have very fixed positions, but really what's their outcome? What's their end goal? What are they trying to achieve? And is there a way to think about the dispute in a broader way that will allow parties come close to their ideal outcome, if you like? The process is confidential, as most mediations are. Again, one of the features of CAS mediation is that if the parties do reach agreement, they can set that out in a settlement agreement. And once that's signed up to, it has binding effect of a contract. So throughout the mediation, the process is voluntary. The parties can step away from the mediation process at any point if they feel it's not working, if there's no point continuing. But at the point where the parties reach agreement, that is then set out in a settlement agreement. And once that's signed up to by the parties, you then have a binding agreement, a binding outcome to your dispute. If mediation fails, so if the mediator and the parties don't come to an agreement, if the parties can't agree on an outcome to their dispute, then they can agree to submit the dispute to CAS arbitration. Now, the default position is that the mediator cannot act as arbitrator, because I suppose it makes sense that if the mediator is having these one-sided conversations with parties, he or she will be privy to information that the party may not necessarily want to disclose in an adversarial arbitration proceeding. So the rule is that a person who sits as a mediator under the CAS rules cannot then sit as arbitrator on that same dispute. However, there is again a caveat that the parties can expressly agree to it. So I suppose respecting the autonomy of the parties and the great deference given to the parties to agree to the extent they can how an arbitration is going to run, they can agree that yes, this mediator attempted to resolve our dispute with us, we are unsuccessful, but we want that same person to act as our arbitrator. So there is that possibility, if you like, for the MED-ARB procedure. So that in a very top level oversight is an overview, if you like, of the CAS mediation rules. In terms then of just a couple of examples of mediations I was involved in, one of them was interesting because it really opened my eyes to the psychology of dispute resolution. And it was interesting, again, listening to Deryck speak about the philosophy of sportsmen and sportswomen whose absolute reason for being is to win. And this idea of somehow settling or compromising jars with that starting ambit of I must win. The case that the first mediation I want to speak about was a dispute between a football club and an agent. And the dispute really centered around the fact that the agent, his position was that the club owed him a fee and hadn't paid it. And the club's position was they didn't owe him anything. In advance of the mediation meeting, the mediator held these one-sided conversations by telephone with each party to get an idea of what the issues were, what the main points were, and also again to try and see where the areas of concession might be. The parties came to the CAS and we were all in a room the morning of the mediation. So the morning part of the session, if you like, was quite adversary. Both sides were very entrenched in their positions, and it was hard watching. It was very hard to see how are these two sides going to come to any kind of agreement where it was very black and white. One side said, you owe me money. The club said, no, we don't. So how do you find a resolution there? And the mediator did something very interesting in that over lunch, instead of asking the parties to withdraw to their recess rooms, he invited everybody to stay in the same room. So we all stayed in the same room and ate our lunch around the same table. And that created an incredible shift in dynamic. So instead of the people sitting there as strong adversaries, they were suddenly sitting at the table, eating a sandwich, drinking a cup of coffee, and speaking about the weather. And speaking about, how did you get here? I took the train, I flew. And it really caused a shift, I think, in how they saw each other, that they weren't looking at each other as absolute entrenched adversaries. They were looking at each other as humans. How did you get here today? Would you like another sandwich? Who wants coffee? And when we went back into the afternoon session, the atmosphere had completely changed. And the party settled quite soon after lunch. So that, for me, it was a very interesting example of the need to step away from these very entrenched positions, the need to kind of get people to see each other as humans and to have a different understanding of what's going on. The second dispute that I was involved in, which it started actually as it was a governance dispute, where there was a dispute over who the proper president was of a federation, who was a properly elected president of a federation. The case went to arbitration first, and the parties then agreed to try mediation. Now, at the point that the case went to arbitration, as you can imagine, the personal relationships had completely broken down. There was an absolute breakdown in relationships. The parties agreed to go to mediation. We spent practically a full day at mediation. And by contrast, in this case, both parties stayed in their rooms. So we didn't actually have any point where we were in the same room as the other side. We stayed in our rooms, and the mediator shuttled back and forth, trying to find out where the respective parties were, where areas of concession might be. We did get as far as drafting heads of agreement, but the parties couldn't agree the absolute terms of the agreement. So the mediation failed. A few weeks later, we were called for hearing. So we appeared before an arbitrator, so a different individual who acted as arbitrator. And at the outset of the hearing, so after the opening statements had been made, the parties asked for time to mediate. So we did, we withdrew into our rooms. Or sorry, at that point it was really a negotiation. We no longer had a mediator, but we entered into settlement negotiations and settled pretty much on very same terms as the terms which had been earlier negotiated in the mediation. So I think that's it's an interesting example of, even on the day when the mediation appeared to fail, you could see the value of it then a few weeks later when we went to arbitration, when we withdrew and negotiated, and we ended up coming out to a place very close to where we'd been in terms of the mediation. So that's my few minutes worth, if you like. And again, thank you very much to Mr. Dutta and to the organisers for asking me to speak here today. It's a pleasure to address so many of you online on screen, and I very much look forward to the rest of the conversation and debate. Thank you.
Thank you very much, Louise. I must say, a very, very balanced overview. And no matter what we perceive from each other in this world, I think your best comment was that we will continue to discuss issues and we will try and resolve them. I think Deryck also must have got some answer to what he feels, and then I think Deryck is not alone. There are many of us who feel that way. But I think one thing that is, of course, you explained the CAS rules, and of course we have so many questions about CAS that keep arising in our mind from day to day. And I think your practical examples which you gave are very, very encouraging. In fact, that they go to the very essence of mediation, you know, and how the human psychology plays such a role in the lives of people when they are sitting, you know, with a fixed mind, and suddenly they let loose, and then they start considering very, very positively. Thank you so much, Louise. And our next speaker, of course, today is another absolutely a stalwart in the field of arbitration and sports. It is the Honourable Mr. Justice Graeme Mew. The Honourable Mr. Justice Graeme Mew was appointed to the Ontario Superior Court of Justice in December 2013. Previously, he practiced as an advocate, arbitrator, and a mediator in Toronto with Clyde and Company, and in London as a member of chambers at 4 New Square. He holds law degrees from Kingston University, United Kingdom, and from the University of Windsor, Canada. He was a member of the Bars of England and Wales, Middle Temple 1982, Ontario 1987, and British Columbia 2010. His practice concentrated on civil litigation, insurance law, commercial arbitration, and mediation and sports disputes. He is the author of Law of Limitations, published by LexisNexis, currently in its 3rd edition. He has been a judicial and appeals officer of World Rugby since 2001 and a member of World Rugby Anti-Doping Advisory Committee since its establishment in the year 2000. He was a member of the ad hoc panels of the Court of Arbitration for Sports at Commonwealth Games in 2010, New Delhi, and the Olympic Games in 2012 at London. He was president of the Commonwealth Lawyers Association from the year 2005 to the year 2007, and currently serves as a director of Sports Dispute Resolution Center of Canada and Ontario Superior Court Judges Association. Mr. Justice Mew is an instructor at the Faculty of Law at Queen's University, Kingston, and is a bencher of the Honorable Society of the Middle Temple. So the participants, ladies and gentlemen, panelists, please let us now open the stage to Justice Mew and hear him. Justice Mew, we are all ears.
Thank you. Good afternoon or good evening, everyone. Welcome from Kingston, Ontario, where we're having what we describe as an Indian summer. It's a beautiful late autumn day here. So although I like Louise, I have very fond memories of the time that I spent in India, and hope that when the current madness in the world subsides, that I'll be able to come back. Some very interesting comments from my colleagues so far, and I won't repeat what Louise said, but I now teach my students at Queen's University about, amongst other things, the CAS, and I share Deryck's view of the Samanya decision. But I think it's important to remember with the CAS that just like any other court, it's an independent arbitral body, and many of you will recall that the same body, the CAS, made what I think we would all regard as a very progressive decision in the case of an Indian athlete, Dutta Chan. And that case led indirectly to World Athletics changing its rules, which were challenged in the Samanya case, and it was a 2-1 split. One of my Canadian judicial colleagues was on the panel, and I don't think it's a great secret that he was the dissenter in that decision. So I think, just as with any other adjudicative body, there are certainly improvements that can be made, both the optics in terms of how that tribunal is regarded, as seen by its constituents, and also its substantive organisation. Also very interesting, I followed the case in Trinidad involving the Soccer Association, and some very profound issues of how sports disputes get resolved. Essentially, a court case was taken in Trinidad to effectively, because the CAS process had been seen as prohibitive is unfair, the Soccer Federation, Football Federation in Trinidad went to the court and initially was successful in establishing the right of the local football federation to effectively sue FIFA in a domestic court. They didn't do so well in the Trinidad Court of Appeal, which upheld the jurisdiction of the Court of Arbitration for Sport. And Deryck, I don't know if the case is going up to the Privy Council. I saw there was some talk of that. So who knows? There may be another chapter in that story. But what it does illustrate is, as Deryck and Louise have both underscored, is just how important sports is in our lives and how important the resolution of sports disputes is. And generally speaking, and I say this now as a sitting judge, courts are not well equipped to deal with sports disputes. We don't move quickly enough. We don't have the expertise that's required, and I think it's difficult for athletes in particular to be confident that they will get fair and expeditious hearing in a court of law. And in Canada, we have progressed to the point where we now require, as a condition of sports organisations receiving funding from government, that sports organisations do not resolve their disputes in court, and that they go instead to the Sport Dispute Resolution Centre of Canada, which is an independent tribunal which provides mediation, arbitration, and now recently safeguarding services to the sports community in Canada. And I'm going to devote most of the rest of my comments about some of the work that organisation does. I think in mediation, and again, Deryck and Louise have both touched on the cultural issues, why mediation is sometimes a hard sell in sport because of the culture of sports people. And often in international sports, you also have a clash of different legal traditions. But it's important to remember that mediation is ultimately, as Deryck indicated, a structured negotiation. It's a form of communication between parties, mediated by a neutral person. And although some sports disputes are particularly challenging, you think of a selection dispute, for instance, to give Deryck's win-lose analogy, if there's only one spot on the team available and there's more than one person who claims to be entitled to that spot, someone's going to win and someone's going to lose, and there is no compromise. There will be a winner and there will be a loser. So a sort of 50-50 midway solution is not possible in those circumstances, and that makes the mediation challenging. But on the other hand, mediation can achieve negotiated outcomes that an arbitration or a court decision cannot. And I'm going to give you a couple of examples, as Louise did of mediations I was involved in where that occurred. Before I do that, though, let me very briefly describe the system that over 20 years or so we've evolved in Canada. There are essentially, and I think our chairman has indicated this, 4 general areas of sports disputes: doping, team selection, funding, and athlete support, and a lot of countries provide financial support to their elite athletes. And then the sort of administrative governance issues that sometimes pit sports organizations who seem to have a real talent for infighting, that pitch people within sports organizations against each other, or sometimes athletes and coaches against sports organizations or the like. And they all present different challenges. We've developed a process with the Sport Dispute Resolution Centre, and I should, if anyone's interested in in finding out more about it, I'll post in the message box after I finish speaking the website, because you may find it interesting to take a look at the
Justice Mew, 1 second. There is a slight disturbance in the sound that we are getting. We are not probably you'll come a little closer to this to the mic so that we can hear you clearly. We are so keen to do that.
Okay, if there continues to be a problem, let me know and I'll put a headset on. Is that sounding better? Okay, all right, my apologies for that. So we developed a process. Parties, as Deryck said, mediation is supposed to be a voluntary system where parties agree to try and negotiate a dispute. But we also have a process that we call resolution facilitation that is now built into every sport dispute that goes to an arbitrated solution. And it requires the parties, in most cases, it's voluntary for doping cases, but in other cases it's mandatory for the parties to spend sometimes as little as an hour on the telephone with a mediator to essentially talk about the upcoming arbitration and see what the prospects for resolution are and whether the parameters of the dispute can be narrowed. And so that's been relatively successful. And you may be surprised to know that we use that process in doping cases. When we had our preparation session yesterday, we talked a little bit about the notion of plea bargaining in criminal law and how that translates into doping cases. We've had considerable success with achieving an agreed upon outcome in doping cases. It's rarely the situation in doping cases that there's a dispute about whether an anti-doping rule violation has occurred. The debate is nearly always about the sanction. And particularly now where sanctions can be modified if somebody provides substantial assistance, which enables the doping authorities to perhaps catch other dopers, that the ability to have a resolution facilitation, as we call it, has been very advantageous. Now, in the 2 or 3 minutes that remain, let me just give you a couple of examples of mediations that achieve the solution that an arbitration cannot have. One of the very first mediations that we did in Canada involved a team selection dispute. And I can tell you about it because it became very public as a result of the participants speaking about it. The complainant was a very accomplished Indigenous athlete. So when I say Indigenous, she was what we call a First Nations person, a Mohawk. And she was, having been on the gold medal winning water polo team in the Sydney Olympics, she was removed from the team a couple of years later. And she said that she was removed, the reason given was team incompatibility. And she said, this is not about team incompatibility, this is about racism. It's about me being culturally different and not fitting in. And so she applied for, which initially sued, and then it moved into mediation. She wanted to be reinstated to the team. In my wisdom, I decided that I better have all the team members at the mediation, and we had a room full of very powerful athletes who all had very strong opinions. But a little bit like Louise's description of how sitting around and having sandwiches and coffee and chatting in between formal sessions helped break the ice. That sort of process evolved during the course of the day. Well, what was the solution? Because if this woman was going to be restored to the team, someone else would have to be thrown out. As the discussion went along, she came to realize that. She realized that reinstatement of herself was not going to be viable. So what we turned our focus on was how some of the concerns she raised about what she saw as systemic racism or intolerance or lack of understanding of cultural differences could be changed. And we ended the day with a very strong agreement on the part of all of the participants, and in particular the National Federation, to change its ways, to change its policies, to extend its understanding and education of cultural differences. And essentially a protocol was put in place to guide conduct in the future, which everyone went away happy. Now, I've got about 30 seconds left by my timer, so let me just tell you very quickly about the other one, but I think you'll find it very satisfactory from a sports perspective. There was a dispute involving selection of a wrestler to the Greco-Roman wrestling team that competed in the Commonwealth Games a few years ago. And both two athletes claimed that the rules hadn't been followed, felt very strongly about it. And so there could only be one winner and one loser if the match had been adjudicated. What the participants decided to do ultimately was to have a wrestle-off. They decided that rather than go to an arbitrator, they would have a wrestling match against each other. In fact, it was the best of three, and that would determine who would be selected to the Commonwealth Games. It's the ultimate in a sport solution. Those are my comments. I look forward to hearing the rest of the presentations and any discussion that follows.
Thank you very much, Justice Mew. I think one very important point that you made, which of course we are all also grappling with, and that is that the courts are not well equipped with the expertise to decide the sports disputes. And I think recently in India, many courts, especially Delhi High Court in at least 2 decisions, has said the same thing, that we are not so equipped to decide and deal with these disputes. And also one very interesting thing you mentioned about was the funding from the government. And I think that is another common aspect that we have. And that's what is sort of falling on the federation's independence to deal with the sport, and the government's interference, as we want it to be reduced. Of course, we want to come up to the level of the Olympic Charter, and we want to have, of course, in a country like India, it's very difficult for sports organizations to have the wherewithal to deal with such a lot of land, equipment, and also athletes, etc. So the government does have a policy, and our constitutional provisions in the Constitution also provide that the government will frame the policies. And of course, finally, we'll have to leave the federations independent. And of course, you raised the cultural issues and also said that mediation can achieve a lot. And then you also mentioned about the resolution facilitation that is voluntary. And I think that's also a good solution. Of course, I think as Louise mentioned earlier also in the CAS rules, now we understand that mediation is the first step. And then if the mediation fails, then we go into arbitration. Dear participants, now may I bring you to our last speaker, and who is none other than our own very dear Justice Sikri, Justice Arjun Kumar Sikri. And let me briefly introduce Justice Sikri to you all. And of course, the Indian participants are well aware of him, but of course, the participants from abroad. Justice Sikri did his BCom honors from University of Delhi in 1974, and 2 postgraduate diplomas in company law and administrative law from the Indian Law Institute in the years 1975, 1976. getting first position in both. He topped the LLB from Delhi University in the year 1977 and completed his master's in law in the year 1980. Again, getting first position in 3 years course. He was conferred the LLD honoris causa from Ram Manohar Lohia Law University, Lucknow in the year 2013. Justice Sikri started his practice in Delhi High Court in the year 1977 and handled all types of cases with specialization in arbitration, commercial, labor, and constitutional matters. He was counsel for various public sector undertakings, banks, financial institutions. He taught law in the Campus Law Center from the year 1984 to 1989. In the year 1997, he was designated as a senior advocate by the Delhi High Court, and in the year 1999, he became a judge of the Delhi High Court, and in the year 2011, he became the acting Chief Justice of Delhi High Court. In September 2012, he was elevated as the Chief Justice of Punjab and Haryana High Court, and in April 2013, he was appointed as Judge of the Supreme Court of India. He superannuated in March 2019 as the senior most puisne judge of the Supreme Court of India. Justice Sikri has authored over 4,700 judgments in different fields of law. He was chosen as one of the 50 most influential persons in the world who impacted the growth of intellectual property laws for the year 2007 by MIPA. He wrote many scholarly articles and learned papers. Currently, he is the judge of Singapore International Commercial Court, SICC, chairman of National Court Management Systems Committee, NCMS, chairperson of the Committee for Formulating an Action Plan for Online Dispute Resolution, Niti Aayog. That's the policy-making body of the Government of India. He is chairman of News Broadcasting Standards Authority, NBSA, chairperson, Interim Advisory Council, Delhi School of Public Policy and Governance, DSP&G, University of Delhi, and ombudsman of Federation of Indian Fantasy Sports, FIFS. He is also the visiting professor of various law universities. Over to you, Justice Sikri. We are all awaiting for you to give us your comments today.
Thank you, Mr. Rajiv, for your such a generous introduction, which was not needed. Anyway, I am beholden to you for that. My greetings to all my fellow panelists and to all the organizers, and good evening to all the participants who have come in large number. Here, their registrations, and which I can see that many of them are participating. And it's a very interesting topic. I should first congratulate you for organizing a discussion on mediation in sports matters. That is very topical and very important in today's date, particularly insofar as India is concerned, because of various reasons, which I'll try to demonstrate over next 10-12 minutes, which I have been given to address. What I gather at the outset, let me make these remarks. What I gather from my three distinguished speakers who have spoken, there are two very, very important takeaways among so many others, but the two which I would like to highlight and then would start insofar as relevance of those takeaways insofar as India is concerned. First thing, which Justice Graeme, you said, and Rajiv also summarized that the courts are not well equipped to decide disputes as far as sports disputes are concerned. Another, of course, on that there is some difference of opinion which we saw. Deryck Murray says that insofar as CAS is concerned, here CAS is what it is, the arbitration body that the sports cases which go to them, and the manner in which the arbitration takes place. And he had some of his reservation. Of course, Louis tried to allay those apprehensions which he had. But what I'm trying to say here is that to some extent, and this I'll try to make it good later, to some extent there is some reservation insofar as resolution of disputes either by the court process or by arbitration is concerned. And in this whole process, mediation assumes great significance. And all the three speakers have stated what is the importance of mediation insofar as sports cases are concerned. We have seen actually the disputes, as far as sports disputes are concerned, they are of different nature. I need not repeat that because that has been said time and again. But what is important is that these, as far as relationships in sports are concerned, they are different from other commercial relationships. Although in commercialization of sports also has come in, which involves influx of money, etc., and that it has given rise to various other kinds of issues and disputes, etc. That's a different thing. But what is even today it is important is that sports, as Deryck said in the beginning itself, when he compared sports with the mediation, that sports is one thing where everybody wants to win. So there two sports persons who are competing with each other, whether they are two teams or two players who are competing with each other, they take their positions because both of them want to win. It is, but as against that, mediation is a win-win situation where both come together and they want to find a solution if there's some disputes are arisen. But what he highlighted was level playing field, which is created by various means. And I'll add to that, that mediation is one such process which facilitates level playing field, so that the competition which is there between the two parties, they may be called two sports teams, etc., may be called warring parties, but then they, at the same time, we recognize that as far as sports is concerned, it is, and in respect of cricket, it is said it is a gentleman's game. So it is given that stature. And we normally use this phrase when we want to say somebody that, look, you should have sportsman spirit. So this kind of spirit, so this is what is the importance which is attached to the sports. This is the culture of the sport. And because of so many reasons today and all these kinds of issues which arise, whether these issues may be for selection of teams, for a particular athlete or particular sportsman in that particular game not selected in the team, or whether it is a doping, whether it is sharing of revenue insofar as organizers are concerned, whether it is even say sponsoring the teams, etc., the issues may arise between them, and some issues have arisen. And there have been issues apart from that, issues of, as particularly in India, in these bodies, sports bodies, issues of elections, issues of corruption in sports. And when all this takes place and the process, when it is gone into the due process itself comes into picture. And another aspect which I would like to add is the which we have seen in India, particularly the cases of that kind, gender discrimination and sexual exploitation. There are many such cases which have come that the coach had tried to indulge in such kind of practices, and that there were some complaints against them. And so therefore, what I'm trying to say is that the issues in respect of sports, which is highlighted by my predecessor speakers also, are of a different nature. At the same time, what is more important is that these issues need to be resolved immediately. They cannot wait even for a few days sometimes if some game is going on. And that is why many sports bodies have their ad hoc committees and those ad hoc judges, or you call them arbitrator or mediators, they are there in the events. As Justice Graeme, we were told that he was here in 2010 Commonwealth Games. So therefore, that need is there, because we need on-the-spot resolution. So what I'm trying to say is, when we talk of on-the-spot resolution, it is neither the court system, nor that is litigation, nor arbitration system which can deal with this effectively. That is one reason. And here, when we talk of mediation, and let me say here, Louise gave very nice example when she talked about one mediation case, that during lunch, that the mediator asked both the parties to sit together and have lunch with him. When they were sitting on one table, and they had their lunch and they had their coffee together, and they were discussing weather or their journey, etc., coming to that place. So the entire atmosphere changed. This is the, I would say, the best policy or the best trait of a mediation. What I call it, if I may say, and why disputes arise? Because in any society, conflicts would arise. There cannot be, a society without conflicts. But what we want is the early resolution and peaceful resolution of those conflicts. And why mediation is one such a process which goes into the reasons why disputes have arisen. And it not only looks into the past, but it looks into the future also, so that the relationship between the parties is maintained. So going by that example which Louise gave, that two parties sitting across the negotiating table and discussing, I call it a position from I versus you, because we have the habit of taking our positions when we go to the court or we go to the arbitration, which are adjudicatory processes. Then we take our position, and I think I am right. You think you are right. But on a negotiating table, on a mediation table where there is a third person who is a neutral and is facilitating the mediation process, a mediator, this is converted from I versus you to we. We are now sitting together. When we sit on that table, I see your point of view also, you see my point of view also. And this is the situation of which I call a synergy, which takes place. And it brings about wonderful results. That is the process of mediation which needs to be there. And as I say that discussions are always better than arguments, because an argument is to find out who is right, and a discussion is to find out what is right. So from who is right to what is right, in that kind of situation, it is only the mediation which brings about, that is, it heals the past, it lives in the present, and it dreams the future. When we see these kinds of the advantages of the mediation, now, very interestingly, if we see in Indian context, because we are discussing that mediation has taken off in India. It started with the amendment in the Civil Procedure Code with the insertion of Section 89 in the year 2002. First, thereafter, within 3 years, first pilot project of mediation. And at that time, it was a structured interactive mediation, which Deryck also gave that definition of mediation. This started only 15 years ago. We talk about mediation in India in the form of panchayats. We say that we give a very nice example of Krishna going to Kauravas, and he tried to mediate before going for war, since Kaurava did not agree, and therefore war took place. But then the kind of structured scientific method of mediation, present kind of mediation, it is in India, it's at a nascent stage. But good thing is that in last 15 years, it has really come off. And today, mediation is here to stay. It is in the beginning, I still remember in 2005, when the first mediation center was set up as a project, pilot project. undertaken by the Supreme Court and this center was set up in 30 Hazari, lawyers boycotted. They protested. They even ransacked that mediation room, I still remember, when Chief Justice of India had to come. But today, it is the acceptability, particularly among lawyers, is so, fascinating and so encouraging. So in 15 years, we have come a long way. Then, but the mediation has, by and large, has remained what we call court annex mediation, the cases which are in the court, and they are referred for mediation to mediation centers, etc. We are now enlarging the scope and the canvas on which the mediation should take place, including pre-mediation here. And therefore, we are going, and traditionally it is the, say, matrimonial cases or commercial cases or other kinds of cases which are referred. But the time has now come to have the mediation in these particular fields also. And here, the mediation in sports, because of all these peculiar features, it becomes very, very important. I still remember, I'll come to that, I'll give few examples of Indian courts which have taken up the cases and what would have been the position if it would have been mediation instead of litigation. But before that, if I remember, there's only one case. I was just, although it was not mediation in that sense, but in loose sense mediation. Quite a few years ago, maybe 10 years ago or so, Delhi Ranji team was selected. In Ranji is a league, cricket league, which is played, and for Delhi, which had to participate, and team was selected, and on selection, there was a dispute. Now, before this dispute could go to the court, which every time it goes, such disputes, but in that case, at that time, Mr. Arun Jaitley, we know our one of the most established and distinguished lawyers and politicians in this country, who unfortunately passed away last year, he was asked to mediate, and he could bring about a solution within one day. And the Ranji team, everybody accepted the as far as thereafter the team, and it was a win-win situation which was created by that. Another example, not in India, but which apart from the examples which others have given, as I remember, it is Woodhall-Warren case, which Louis or Graeme or Murray would be knowing. So Woodhall, who was a middleweight boxer, and this Warren was his promoter. And they had a contract between them. He refused to play, maybe on the terms which was stated in the contract. But then good thing is that instead of going to the court, that case had gone for mediation, and it settled, and they came out with a new contract. So it was that kind of win-win situation which had taken place. And therefore, this I had read somewhere that Dominique Bray, who was Warren's lawyer, he said at that time that mediation in sports is being accepted with open arms. That was his comment after this successful mediation. Now, so therefore, time has come, as far as India is concerned, to have specialized mediations, and it includes sports mediation as well. Now, COVID situation in our country, or worldwide, this COVID pandemic, has given us another fillip or a chance. Of course, it is one pandemic which has created panic all over the world. As I always say, the three aspects which are totally affected are lives, people are dying, livelihood, many have been rendered unemployment, and lifestyle. That lifestyle today also, instead of having this in-person physical program, we are all sitting on and having it visual program. So with mask and social distancing, so lifestyle and livelihood, which are affected because of the 3Ls, because of this. But then in the whole process, we have also realized that technology can play a very, very important role. And ODR, which is the online dispute resolution, which is now is seen as a next step even in Indian legal system, whether it is arbitration, whether it is litigation, whether it is mediation. And according to me, some of the cases through mediation, which are apt or which are very proper on online mediation, apart from consumer disputes, are the sports disputes. As Mr. Dutta said about about when he was reading my CV, he said that I am the ombudsman of FIFS, fantasy sports, this thing. So this is where the players, they play, of course, it's a fantasy game and sports that they play and then they win money. But if there are disputes, then these disputes are settled, they come to me and I settle. But what I'm trying to say is that even in these kinds of bodies, etc., what is felt and what is being highlighted is that it is not necessary to go to court. There should be a self-regulation. And here mediation plays a very, very important role in the whole process. And therefore, it was also said ODR, I'm the chairman of the advisory committee. Niti Aayog is looking into that, and we are coming about with this today because of all and ODR and COVID situation. It has been felt, and particularly after the Singapore Convention, which came into force in this September 2020 itself, which was initiated last year in 2019 and has been on UNCITRAL rules. And it is going to be a game changer, because even international disputes of any kind, when they are settled through mediation, like in arbitration, when we have this Geneva or New York Convention. So under the Singapore Convention, when the parties sign, that mediation in one country or wherever it happens will be accepted in other country like an arbitration award. So it is going to be a game changer. And in this scenario, when mediation is taking place, such proper and good routes, I think in India, we should now gear up and should start how we can do mediation in these. I think I need not go further, because I have already overrun my time. I wanted to give some of the examples, but I'll rest at that. Yeah, thank you.
Thank you very much, Justice Sikri. And I think the catch point in what you have said, of course, is who is right to what is right is what we are trying to absolutely find out. And the courts, of course, as you said, are not so well equipped, and you have mentioned some of the cases. The important thing in mediation, and as you also rightly referred to how Deryck started by saying that the sportsmen want to win, but they want to win on a level playing field. And on-the-spot decisions of mediation are absolutely a must, and that's what helps sports in growing, because disputes will be everywhere, and this society cannot be without disputes. And I think we have had a very long session. A lot of things have been said, and I think a few questions which have come through. But I think very before I hand over to Arun for his closing remarks, may I just put 2 or 3 very simple questions which most of the people have. We have gathered them from a lot of questions which people want to ask. And one of the questions that any one of the panelists from, let's say, Louise or Deryck or Justice Mew, one question that is in the mind of many people is, how do you in the West and other parts of the world consider the idea of court-appointed mediations? Anyone can take that question.
Well, maybe as a court person, I'll take a stab at that. Again, we've had a mediation as part of our court process probably for 25 years now, and indeed in Toronto, which is our biggest court centre in Canada, parties are required to have a mediation session before they can set an action down for trial or obtain an exemption through court. It's often said that a mandatory mediation system is an oxymoron, that mediation can only work if it's interest-based and if it's voluntary. And certainly the settlement rates in voluntary mediation are higher than they are where mediation is mandated by the courts, but not significantly higher. For all the reasons that have been discussed by the speakers today, once people are put in a room together, and sometimes, as Louise explained, they're not always together. Sometimes their enmity is such that they have to be kept apart, and the mediator plays a shuttle diplomacy role. But once you put people in a position of having to communicate, and it's not in the set piece of a courtroom, there is usually progress that can be made, even if it's just having a better understanding of the case that you're going to have to meet in court. So I'm a fan of mediation. I think it takes disputes that don't need to be adjudicated out of the system. And even if those disputes stay in the system, the parties go into court with a better understanding.
Thank you very much. And Louise, any comments on that?
Yes, I think Ireland, similar to Canada, there's been some development to encourage mediation in Ireland. And specifically, the Irish government brought in the Mediation Act in 2017. And by virtue of sections 14 and 15 of that 2017 Act, before legal counsel, so before either a solicitor or a barrister commences proceedings on behalf of a client, he or she has to set out to the client the possibility of going through mediation as a means of resolving the dispute. So it's too early really to see what impact that has had, but at least the legislative framework is there that now, before commencing any procedure in the Irish courts, there is a positive obligation on the solicitor, or where the barrister is acting without a solicitor, to inform the client about the possibility of mediation. So at least it creates awareness of it. The client at least turns their mind to the possibility of mediating the dispute before going into a fully adversarial court litigation.
Thank you. Deryck, do you have any comment on that? Deryck, you are muted.
Yep, sorry. Yes, yes, I know that this is being tried in Trinidad and Tobago, that there is such a large backlog of cases before the courts that they, from time to time, have projects that do a batch of mediations as opposed to going through the court process. I'm sorry I don't have particular facts and figures to give you, but while I have the floor, Mr. Mediator, I just want to say to my other colleagues on the panel, to thank them for their contributions. I think overall this has reinforced my optimism, certainly, that sport is unique and will continue to throw up role models and be a catalyst and motivation for making and achieving goals wherever they may be. And I'm heartened by the other colleagues' comments that by discussion, like webinars like this, that we will go forth and be productive. And I trust that everyone who participated has them and their families stay safe during this COVID period. And who knows, maybe we will meet up in the Bahamas next year if possible.
Surely. One comment I want from Justice Sikri. Sir, you have already, you are muted, sir. So as you have already mentioned, that there are disputes. Of course, the power of Article 32 and 226 under the Constitution is very vast with the courts. When the disputes for sports are going to the courts, and today there are very many federations, even Indian Olympic Association, it has set up a disciplinary committee, etc., etc. why is it that the courts are not keen to first send these disputes straight away to mediation? Of course, we are awaiting the standalone law for mediation, and probably you could influence that in that law. We have a chapter relating to mediation on sports where it could be only through mediation.
See, I think it's a very valid question, Mr. Rajiv, which you have raised. What I can say is there may be two reasons for that. Number one, the philosophy of the judge itself. So there are judges who have been encouraging mediation, and whenever such cases come, they try that, yes, the cases should be, I mean, they will tell the parties to that the cases should be sent for mediation, and you first take a chance there. And many kinds of cases have been sent by various judges. There's no doubt about it. Insofar as sports cases are concerned, what I find is that maybe occasion has not arisen because of that second reason. As you rightly mentioned, sometimes the disputes are such that a writ petition is filed either under Article 226 or 32. So therefore, there's some constitutional issues which have been raised. And once there are constitutional issues raised, it may not have occurred. I'm not saying it may not have occurred that such case could also be sent, because they many times you people as lawyers, you know, because the ingenuity of the lawyers is unbound. But in order to file the writ petition, they will raise some constitutional aspect, which may not be very necessary or very genesis of a dispute. And because ultimately at the end of the day, the two parties to a dispute, they want resolution of the dispute. They don't want a very brilliant judgment on whether a sports body like BCCI is I mean, state under Article 226 or not. This is no concern of the parties. This may be the concern of lawyers, and whether writ petitions are maintainable or not. As far as parties are concerned, they only want resolution of their disputes. So therefore, maybe it's a very good idea which you have said. And I think there may be some good webinar or seminar of this kind where the judges should also be, to some extent, we have some of the judges who are really good in Supreme Court who are for mediation. E-committee chairman today, Justice Chandrachud, Dr. Chandrachud is again
forward-looking.
Yes, and Justice Kaul, who is heading the mediation and conciliation committee with Justice, I think he is heading, or Justice Rohinton Nariman is heading, and the third person is Justice Indu Malhotra. So all of them are there. They have passion for mediation. There's no doubt about it. But this message should go. I was just remembering one of the examples which I wanted to give was a case came before me, and it was BCCI, although it was telecast rights, etc., that it had a contract with World Sports Group, and which was, I think contract was rescinded way back in 2009. And of course, there was an arbitration clause, so matter went for arbitration. Arbitrator, the arbitral tribunal passed some interim arrangement, they are fixed, but then it was challenged. And till 2014, 15, 16, the matter was pending in the Supreme Court to decide this issue. So interim arrangement, etc. So it takes 5-6 years only on interim. So that is the time which the arbitration can also take, even if the matter has gone for arbitration. So therefore, such cases, if we can find a fast resolution through mediation, and as we always say, win-win situation. Actually, I tell you, we have two types of cases as far as sports are concerned. One is, yes, which are concerning the sports bodies in the sense that players, not team selection, doping, and other things. But then we have lots of disputes about the administration of the sports bodies, also about their elections, also about corruption, scams, etc., all those kinds of things. So which fall in a different category altogether. So some of these category of disputes, they cannot be through mediation. They have to be through adjudication. If suppose the case of some corruption or scam, and some FIR is filed and it is before the criminal court, it has to be gone into like that only. That can't be settled through mediation. But at the same time, like when we were discussing yesterday only, and Mr. Aruneshwar Gupta mentioned, or I think, yeah, Mr. Rajiv, that you only mentioned about plea-bargaining.
Yes,
so
right.
some of the cases, even in the criminal procedure code, plea bargaining, I always say, is in criminal cases, it's a form of mediation. So if you say in loose sense, we can call it a mediation in criminal cases. And of course, so therefore, such cases are also, many of these cases in this category are also capable of settling. If they, even under our criminal procedure code, there are certain cases which are compoundable, if they fall in that category, and therefore they can be also be settled. So therefore, there is a vast scope as far as settlement is concerned. Yes, sensitization of judges is needed as far as your question is concerned.
I was just wanting to ask one more last question, and that will go to Louise and Justice Mew. CAS, of course, the seat of CAS is Lausanne. And whatever decision is rendered by CAS, it goes before the courts in Switzerland, in Lausanne. And therefore, the rest of the world, anybody wants to challenge that decision, they have to go to Lausanne. And sometimes the court in Lausanne have a very limited approach to, like in any arbitration law also, very limited aspects they look into. And if it is against the public policy of Switzerland, then of course that award will be set aside. Why is it that of course, every country, every sportsman belonging to every country, that country also has a sovereign, and it also has its public policy. So we are now just bound only with Switzerland's public policy as far as CAS is concerned. Do you have any comment on that, Louise?
See, Louise is looking at me and I'm looking at Louise.
Exactly. Thank you, Rajiv. You saved, I think, your most complex question for last. I mean, just to say, you're absolutely right that the seat of all CAS arbitrations is Lausanne. So that means that where a party wants to challenge an arbitration, and as you pointed out, those challenges are made on very narrow procedural grounds. So one of the bedrock principles of arbitration, if you like, is that the award is final and binding on the parties. Save for these very narrow procedural grounds on which the award can be challenged in the case of Swiss awards to the Swiss Federal Tribunal under the Swiss Private International Law Act. I mean, the question you raise as to whether the Swiss Federal Tribunal should have regard to both international public policy and Swiss public policy is a very interesting one. I think similar to a constitutional argument made before an Irish court, where a party raises a question of public policy, it's really kind of a last-ditch argument. It's where they can't fit their arguments under either jurisdiction or a violation of the right to be heard or some irregularity in the constitution of the tribunal. From memory, I think the case of the footballer Methusalem was the first CAS award where the Swiss Federal Tribunal set aside part of the award on the grounds of Swiss public policy. As to whether the Swiss courts would also take into account international public policy, the short answer is I don't know. I mean, I think it's certainly if you are an Indian party coming before the Swiss Federal Tribunal, and if it's a case where both parties are Indian, and your point is, look, this award is really in clear violation of Indian public policy, then as to whether that argument will be successful, I don't know, but I think it's certainly an argument worth making, where in circumstances where the award itself is going to be sought to be enforced in India.
Thank you so much. Before I close, there's only one thing I want to mention, and I think, Deryck, that will interest you, that there has been a mediation between the West Indies cricket team and the BCCI, which I dug out with my research. And I must say that, the president of the West Indies Cricket Board, Dave Cameron, and it was when the West Indies cricket team decided to abandon the rest of the series in India, that he said, and he said very well, that we would like to resolve this dispute through dialogue, facilitated or otherwise, with aim of jointly coming up with appropriate cricketing solutions. I really was so fascinated by this, that there has already been something between the West Indies cricket team and the Indian cricket team. And now I think we've really taken a lot of time. I think I'll hand over to Aruneshwar for his comments, closing comments. Thank you very much.
Thank you, Rajiv. This was really amazing and a fascinating international webinar, where almost 1,000 participants registered themselves and a large number has attended. The glory of this enthusiasm goes to our panel of speakers, whose wide experience and outstanding brilliance is spread out globally, and that has kept everyone awestruck, fascinated, and mesmerized today. Though I represent the Sports Disputes Resolution Center of India, but I take this opportunity to thank you all, panelists, registrants, and participants, on behalf of Supreme Court Mediators, Commonwealth Law Association, and Youth Bar Association of India. When the first human being threw a stone at an animal to shoe him, or to get a fruit from the tree, or ran with his siblings and friends to test his skills, sports was created. Sports is a disciplined, synchronized, and rigorous physical activity involving human body, mind, and will within the framework of rules for organized participation. It helps in developing integrity of character, confidence, self-reliance, self of well-being. It teaches how to work as a part of team, how to manage success and disappointments, and how to respect each other. Sports is entertainment of Hollywood and Bollywood with military precision. A live entertainment. You lose your focus for a fraction and you lose your gold, or you're back to the pavilion. The wow factor leads to the rise of adrenaline and the TRP, and that is where the money is. And when money is, there is disputes. When there are disputes, there has to be mechanism for dispute resolution. And that is what we have all talked about and heard today. My thanks to Deryck Murray for being with us in this early morning, almost 8:30 Trinidad time. Deryck has evolved as the most experienced and acclaimed mediator and arbitrator over the years, and that we have felt in his address today. The credit goes all to his great wicket-keeping skills, while Andy Roberts and Malcolm Marshall were attacking with full fury, sometimes at Indians also. I think he uses the same said skill in collecting the facts hurled at him by the advocates and he smoothened them into meaningful settlement and awards. His particular reference to existing of big brother and small brother in sports resolution needs serious consideration. Thank you, Murray, for being with us today. I thank Louise Reilly for sharing us her very wide experience in regulatory and disciplinary matters before domestic and international tribunals, particularly an experience as a mediator. Her observation on absence of bias in sports disputes, particularly in view of successive decisions against IOC, were extremely pertinent. She took us through the CS rules, and that will be very meaningful for us in times to come. Thank you, Louise, for a wonderful address to the August gathering, sharing her experience and understanding of the range of disputes that arise between the various stakeholders in the sports industry. It was really a great pleasure to have Justice Graeme from Canada with us. We made him wake up in the wee hours and join us early morning, 7:30 a.m. Canada time. He has a wide experience over 2 decades as a sports mediator and arbitrator, and a judge on the panel of Courts of Arbitration for Sports Dispute Resolution Center. He has, I see in his website, and it speaks a lot about the information on disputes relating to sports. It was also evident from his address, and it was really pleasure to hear Justice Mew's outstanding and fascinating address on the subject. Thank you, Justice Mew. My very personal thanks to Justice Arjun K. Sikri, who is a great enthusiast and readily agreed to be with us today on this inaugural session. His enthusiasm was evident in his very passionate address. His simplicity, effortlessness, and in-depth learning has always been a boon and blessing for the legal institution. It was a treat to hear him and see his vision and way forward with respect to the three nascent industries in India: sports dispute resolution by private courts, using mediation as a tool, and that too by an online process. But all this is irreversible and choiceless. We are in the fourth industrial revolution, globalization 4.0, and as I call, we are also in the legal revolution 5.0. I am certain that under his guidance, Niti Aayog will be able to implement it all at the ground level soon. Thank you, Justice Sikri, for enlightening us today. We look forward to your backing and your support as we have taken up the venture of sport dispute resolution, by promoting and providing the necessary platform for online dispute resolution to all the stakeholders in the industry. When I was drafting the Sports Act for Rajasthan, we came across a list of more than 60 stakeholders in the sport industry, other than the players. His emphasis on going to the root of the dispute, and believe me, and what Justice Sikri said, that all disputes are finally resolvable if we move from I versus you to we situation. My extreme thanks to Justice Sikri. My thanks to Stephen Thiru, Vice President, Commonwealth Law Association, Australasia Hub, Rakesh Khanna, former President of Supreme Court Bar Association, Rajiv Dutta and Jitendra Mohan Sharma, both former Vice Presidents of Supreme Court Bar Association, and all senior advocates at Supreme Court. They hold the flag of Supreme Court mediators and carry it on their broad shoulders with meticulous precision. They have been the rock foundation of this webinar. My thanks to Sampreet Ajmani, a young advocate at Supreme Court representing the Youth Bar Association of India. And finally, my thanks to the man behind the scene, silently, naturally, inconspicuously, and effectively coordinating it all. The Sutradhar of this webinar, R. Santhana Krishnan, former President of Commonwealth Law Association. And last but not the least, thank to Rahul Kumar and his team for providing the technical support in holding this webinar and making it a great success. We are going to hold a series of webinars on various topics related to sports industry and look forward to see you all again and again to be enlightened and seek enlightenment. Thank you all for being with us. Thank you.